Thank you. Thank you very much. Thank you. I appreciate that. You were very much on time. I appreciate it as well. Let's now go directly and give the floor to you, rather than engaging in further kind of commentary. I may have some comments to make as you ask questions in order to be able to clarify things. Please, I would appreciate if you were to identify yourself when you ask a question. Let's also say that it would be good if you confine yourself to one question at a time, and also that it would be better if you actually asked questions rather than made comments, because of course we're all very intelligent people and we can phrase comments in the form of questions, but I think the important thing is to try and elicit reactions from the speakers and from the panel in the form of questions. So I would urge you to try and ask us questions, and if you have a second one, I'll be happy to come back to you after I've taken the round, so I can subscribe to my own need to operate on the basis of fairness. So, who'd like to go first? Sir.
John Wolf.
I think a mic is coming your way, Mr. Wolf.
You mentioned about a reasonable time. From your experience, what would you define as a reasonable time?
I will give you an answer which may appear to be that I'm fudging, but I'm not. What a reasonable time is very much depends on what you have before you. Now, the regulations give very specific time limits. They say you must, in Regulation 1049, you must respond within 15 days, or if you have very specific reasons for needing to in fact exceed it, you can go for another 15 days. Okay, so that would be the legal definition of what reasonable time is. From then on, when you have a request for a very large number of documents, I think it is entirely acceptable for the institution to in fact plead and make a case for a different time of dealing when I'm going to them and asking for explanations and all that. So reasonable time is, in terms of the regulation, very clearly spelled out. Once you get beyond that, or if there are kind of extenuating circumstances, I, as Ombudsman at least, am prepared to in fact consider what, to listen to what would be, compelling reasons for not doing so. But again, I read these regulations and these requirements restrictively, because it is in the interest of civil society and of the complainant that they be read restrictively rather than expansively. Please.
Just shortly to intervene, that's also one of the criticism to the proposed reform by the Commission on the access document regulation, which expands the confirmatory application period to 30 days, which has been widely criticized in civil society, because if in total 45 working days are to be set for a complete request procedure, that's 2 months more or less in practice.
I'd like to give the members of the panel the chance to be able to intervene. So I'll give Mr. Driessen the floor, and I'll just make a very quick comment as well.
Well, from my personal experience, first 3/4 of the documents circulated to member states, and there's about 1 million of them existing since 1994, are directly downloadable on the website. So reasonable time there is 2 minutes. If you ask for a document, it will depend. I mean, as the Ombudsman said, there's the legal 15 working days expandable by 15 working days if necessary. And in my experience in the Council, very often things can be handled in 15 working days. It depends a bit on the request. Sometimes we need a bit more time, and that depends on essentially 2 factors. First, the amount of documents asked.
Yeah.
And we've had, for instance, for years, one NGO being responsible for 1/10 of all documents requested from the Council, and that was every month, literally boxes and boxes and boxes of paper, until we finally could convince them that they could accept it on a CD-ROM after a lot of negotiations. And even then, we asked them to waive their rights as far as a reasonable time, and we will try to do it within 3 months. and you get it in batches per 2 months. If it's really a lot of documents and these requests occur, and often they tend to be not just, and that's the second factor, not just a lot of documents, but also very difficult cases. All the easy documents are nowadays on the internet straight away. If there's no problem with the document, then typically we make it directly accessible on the internet. So what you see is that in the course of years, that the kind of requests that we're getting in the council tend to be for more and more kind of like the hard nut cases, if you want, because all the easy ones are anyway kind of like they're upon production made available on the internet. So that's easy. So the requests we do get tend to be for really documents where we have a problem making them directly available, and we have to go through it carefully. And that often takes a lot of work with the service that authored the document, sometimes with third parties, if third parties are involved as authors, or if typically, or often we get documents, requests for documents on meetings with third countries, and then of course we have to sort of assess like what extent can we give out the information without damaging international relations, that sort of thing. And the reasonable time will indeed depend on that. I've always found it a good kind of rule of thumb, but it's not more than that, that if we have a lot of documents, that we try at a maximum to have a full reply by 3 months in extreme cases, but then you speak about really kind of like the worst case scenario kind of request that we get. In virtually all cases we manage to do it much faster than that.
Let me just add here, because this is a very important general point. From the Ombudsman's point of view, of course, I will judge what reasonable is on the basis of what I'm told. So the institutions need to explain their reasons for doing one thing or another, and if they provide what I would consider reasonable and coherent explanations, I'm much more likely, in fact, to accept rather than not to accept. Mm-hmm. This having been said, let me also add 2 important dimensions here. The issue of whether of delays is something that is clearly plaguing the Commission. In particular, and again, I use the Commission because it is the largest institution and it is the one that is the object of most. It is not an indication of a particular problem that is Commission linked only. But the idea of going to 30 days rather than staying with 15 days in confirmatory stage, for example, is one way of dealing with the problem. My concern is it the best way? Okay. And there might be arguments to be made for, in fact, ensuring that documents are drafted in such a way that, in fact, they will make additional time not necessary. Or to put it again in a different way, and I'd very much like to have reactions from both of you in this area. This is a general observation. All organizations, okay, and I use that in the non-pejorative sense of the word bureaucracy, okay, all complex organizations have a tendency of seeking to exhaust the time limits that they're presented with. So that when I present an institution with a request for a document, I know from experience, from informal contacts, that in fact it will be at the very last day or close to the very last day that in fact the answer will come, even though it could have been handled earlier, because people have to plan their time, etc., etc. And if I have 3 months, well, I'm going to do it a little later. So if you expand it, I don't think that you're going to solve the problem necessarily. This is one of my concerns about the extension. Another problem, of course, is that the very large amounts of data that are requested very often place very heavy burdens on the staff of the institutions who are trying to deal with these issues. Okay, and very often the institutions come to me and say, this is undue administrative burden because there's a particular provision that allows you to get out of deadlines with undue administrative burdens. My position as Ombudsman, and again, done fairly and impartially, not in any kind of confrontational way, is to argue that for an institution to invoke, I don't have enough staff to be able to deal with requests, is not good administration. It is not my concern as Ombudsman, as an external mechanism of control of the institutions, to tell them how many people to be allocated to do a particular job. It is for them to determine what it takes to do the job so they will be within the rules of good administration. So that if you don't do it, essentially you're sliding in the direction of maladministration. Okay. That, again, within reasonable grounds. Okay. Huge requests, abusive requests, clearly come under particular exceptions and they have to be addressed. Okay.
Yes, I mean, I think everything has been said. I mean, a reasonable time frame is also related to the complexity, the volume, and I mean, there are two main reasons for having delays in requesting in handing access requests at the Commission. One reason is the number of documents. Another reason is also sometimes the lack of precision of a request.
Correct.
We receive many requests which are not for specific documents, but which are for any document, any paper, any email concerning a given subject, which means that you have to spend a lot of time searching for possible documents, and we are never sure that you have really found everything which could be relevant. And the other type of request for access to a complete file in a competition case. I mean, the example has been given of a case of 47,000 pages, and we have even had worse. If you really need to look at each of the documents, decide whether or not to disclose it, it is very, very time consuming. And this is the type of document because, I mean, the Ombudsman is right in saying that you should also take the possible dimension of publication of documents into account when you draft the documents. But some documents are specifically drafted not with the purpose of making them public, like for example in investigations,
Fine.
in competition cases.
External relations.
And then and external relations also.
Sure.
So there we have to strike a balance. And I mean another issue. I mean this is an issue that was raised by Transparency International about. There's a lot of information available, but how to find it, and it's very often not in a user-friendly way. And I mean, there is also some progress. It's not only a matter of how many documents, but how can they be found, and are they accessible? I mean, is the citizen able to find them, even if they are available, because of the search techniques? And it's true that very often institutions have a logic which is derived from their own organization. They organize their websites from their own organization and do not necessarily take into account how is the citizen going to search. And I mean, recently the Commission's website, Europa, has been revamped, and they've tried. I mean, my colleagues in the communication department have tried to anticipate how citizens would search for documents to try to make it more citizens friendly. It's not perfect, but
no, but it's clear improvement.
But it's an improvement.
It's
yes.
a clear improvement. Okay.